All right. Good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for protecting the rights of the accused child in care. Whose job is it? Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm going to drop a lot of links into the chat. These will also be included via email and in the YouTube description. It includes a link for our website. It includes links for our social media accounts, so you can find more information about our membership, our committees, and our work groups. This training is being recorded, so if you registered, you're going to receive a copy of this recording via email from Zoom within about 24 hours. But if you forgot to register, no worries, because we will also be posting it on YouTube. It's probably going to be posted this afternoon, so make sure to subscribe to our YouTube channel so that way you get notified whenever we post new videos. I will also post a link for a series page that I've created where there's information about the series. You can find a link to the playlist for our previous webinars, and you can find information about our upcoming webinars as well. So it's all there in one place. You don't have to worry about looking for different emails. The training was approved by the Florida Bar for 1.5 General CLE and 1.5 Juvenile Law Certification Credits. I will I will also drop it into the chat, that CLE code. It will also be included in one of the slides towards the end. It will also be included in the YouTube description. Closed caption are enabled for anybody who needs them. So if you're having any issues with accessibility or captions, you can reach out to me directly. Closed cap, sorry, the materials, I'm going to share two links for the materials. One of them is going to take you to a copy of the slides. Another one is a Dropbox folder that Janine put together with a bunch of great resources, so be on the lookout for that. And if you need a certificate of attendance, please email me after the webinar. I will drop my email into the chat as well. I will make sure to get all those certificates completed. Usually I wait for many people to email me, so I'll start doing all of those at the same time. If for whatever reason I miss out on sending your certificate, feel free to email me again and again and again until I get that certificate to you. So final piece of housekeeping announcements are questions and answers. So we do have the Q&A feature. So if you look into in the Zoom toolbar, you should be able to select the Q&A feature. You can ask questions anonymously. Now, one thing that I do ask is that we will probably address all questions towards the end. Maybe some of your questions will be addressed during the webinar, but we do have a lot of content. We do have a lot of slides, so bear with us. If for whatever reason we are unable to answer a question during today's webinar, I'll make sure that Janine gets those questions so they can be addressed later via email. So with all that said, I'm going to pass it over to Robin Rosenberg, the chair for the Children's Rights Work Group with the Public Interest Law section, and also with Florida Children's First. Robin, the floor is yours.
Hi, everyone. It's good to see you on Zoom. Florida's Children First is a statewide advocacy organization that fights for the rights of children who are in our foster care system and young adults who aged out of care. Um, in addition to doing the systemic work that we do and trying to improve the child welfare system for all young people, we also train and support attorneys, and we do that in part through webinars like this one today and through the Florida Dependency Law Center. So if you're an attorney or judge and are not already a member of the Florida Dependency Law Center, I encourage you to go onto the website and sign up, register to be a user. There's a bunch of great resources there. It's also a communication tool that we use to communicate things like this and other interesting trainings and webinars, new research material, updates on legislation, and that kind of thing. So I'm really excited to be part of this presentation with my colleague Janine Rice, who is part of the team of attorneys that Florida's Children First has that directly represent children. We represent children who are in foster care, birth to 18, and young adults who were formerly in care or who are homeless. Our attorneys are scattered around the state, and we are available to take cases from young people or with young people around the state. So if you're in a jurisdiction that either you have a conflict and you can't take a case, or the existing local attorney resources aren't available to represent a child, please contact us and hopefully we can help out. We can also represent young people who are not entitled to the statutory appointment of an attorney, but nevertheless need their own attorney. We also do civil legal matters for young adults. So our work is not limited to the child welfare system. We've done family law, we've done pretty much any kind of civil litigation on behalf of young people. So we're excited to have you here. I think you're going to learn a lot, and I'm going to hand it over to my colleague Janine.
So good afternoon, everybody. Um, Today we are going to my name is Janine Rice, and in addition to working with Florida's Children First in the capacity that was just described by Robin, I also chair the public interest law section this year. And I've worked as a defense attorney and a prosecutor in the past. So, well, I haven't done that in a few years. I do have that background and experience. So if I cannot answer one of your questions that is very unique or describing a special circumstances, one, I'm not able to give advice, but I can provide information. So as Jorge said, I can loop back to you or circle back. So today we're going to be talking about protecting the rights of the accused child in care. And I think the number one key takeaway is that children in care have the exact same constitutional rights as children who live with their parents. This is important to remember so that children do not feel like they're being treated differently simply because they are not living with their parents. And so if there is someone who is providing shelter, housing, anything that would substitute for a parent, just remember that these children want to and need to feel like they're being treated the same as their peers. And legally, they have the exact same constitutional rights. There's nothing in the law that differentiates them from other children. So the constitutional rights that we're talking about today are those that arise during a criminal or delinquency investigation, but before their first appearance before a judicial officer when a public defender would be appointed. So there is this gap where the law does not require an attorney to be paid for, whether it's by the parent, a family member, a family friend, what have you, or by the government, such as a public defender or regional counsel. So today we're going to learn about what to do and what's happening during that gap, during the investigative phase. And so you're going to learn what those rights are, what those constitutional rights are related to an investigation. And I say criminal or delinquency because you don't know whether or not a child is going to be charged as an adult. So I use that term for this purpose in a hybrid manner, even though there's a different set of rules for criminal defendants than there is for children who are alleged to be delinquent. So we're going to learn about those rights, how they're asserted, and then whose job is it, right? How the adults whose job it is to protect and care for the children in care can protect the rights of the accused child in care. But first, we're going to level set or get on the same page with definitions. And we're going to learn a little bit of Latin in the first two slides. And parens patriae, okay? This is the doctrine that allows the government to intervene in the private affairs of people and to act in a protective capacity, as if they're the father of those people. Like literally, it means father of the people. And in doing so, they typically arises in protecting children, vulnerable adults, or animals who and these are considered marginalized, perhaps don't have the strongest protection, don't have the strongest voice. And so That's where that concept of parens patriae comes in. Oops, where did it go? Next, we had in loco parentis, and that is Latin for in the position of the parent. So standing in the shoes of, right? And it provides the legal authority, it's a doctrine, and it provides the legal authority for a non-relative to act as if they are the parent of the child. So you'll frequently encounter this term in loco parentis in educational settings. So whether the child lives with their parents or with another person, the school is stepping into the shoes of the parent in that educational setting. And when I say the school, I mean it's employees, it's agents, um, because they have to engage in daily parental functions on the fly during the school day. Why is that? Because they're charged with education and they need to maintain safety. And how do they maintain safety? With discipline. And so this is not what this presentation is about, but I did provide some materials in case you're interested in going into that area of that's adjacent to what we're speaking about here today. So once a government has invoked that parens patriae or father of the people doctrine in order to intervene in the first place, we then have to look at who's standing in the shoes of the parent, if anyone is, because remember, up until the time when there's a final judgment terminating a parent's right, when it's no longer subject to appeal and it's final, up until that point, the parents are still the parents. And so, yes, the parents have to be consulted. They still hold the role of parent, but now we're looking at who is closer in proximity when a child is in care because they're not living in the home of the parent, right? They're living in other places that are not in immediate proximity to the parent. So, the practice tip from this is that the person in closest proximity to the child, and that can be closest in terms of physical relationship, and it could be the person closest in, especially when we have an abandonment or neglect type of situation, without getting into the weeds too much, but different types of proximity. And that person needs to be protecting the child's constitutional rights. So what is an investigation? An investigation ranges from an inquiry to a narrowly focused effort to produce incriminating evidence to be used against a suspect in court. So let me take a step back. What is an inquiry? An inquiry is when, for example, this is just one example, a prosecutor is sitting in their office and they're brought a possibility that a crime has occurred. It can come from a walk-in complaint. It can come as a referral from a law enforcement agency. They could read the newspaper and read something. So an inquiry is a low level. There hasn't been an arrest yet. There hasn't been a probable cause affidavit presented. It's low level. And so the prosecutor, who is the ultimate law enforcement authority in a jurisdiction, can conduct an inquiry, determine whether a crime has occurred, and they can use various means of doing that. They can issue subpoenas for records. They can invite the target in to have a chat, like a mere invitation in a non-custodial setting, or they can subpoena witnesses, but in order to really narrow that focus. So that's what an investigation is. And the public generally doesn't know when that's going on, so including the target. And why do I say that? Because you don't always know, and you're not always told by law enforcement in a very candid, forthright, and truthful manner because the law doesn't require them to in this state, whether the child's the target and what they're the target of. So what can happen inadvertently is that law enforcement can get answers that don't satisfy them, inconsistent answers, things that are different, whether it's material or not. And um, people can consent to warrantless searches. And these are some methods by which children can, and whoever is their parent or standing in the shoes of their parent, can mistakenly waive those critical constitutional rights. Or just as importantly, right, when we think of wrongful convictions, can lead the prosecuting authority in the wrong direction away from the true offender. So the practice tip here is that any contact by law enforcement can be an investigation, and presume the child in care is the target. It's better to be safe than sorry in presuming and therefore protecting the child's constitutional rights. The old maxim, better safe than sorry, applies here. So who is a child? A child's any person under the age of 18, unless they've been emancipated by a court order, or with regards to the particular right that they're exercising, they've been emancipated by operation of law. And there's a whole presentation that I did back in January. You can find that on the YouTube, and it talks about, it really gets in the weeds about this. But for our purposes, let's just work on we're not going to get into the emancipation and just say a child is any person under the age of 18. And then if you're concerned, if you're worried, oh, is this child been emancipated? They had a child, da da da. You can go watch that presentation. But the practice tip, which I sort of made reference to in the very beginning, is that children can be charged as adults. And when they're under the age of 18, there's statutes that make it mandatory, and there are statutes that give the state attorney discretion to charge a child as a child under 18 as an adult. And that discretion is exercised so differently from one county or circuit to the next. So when I say there's a lot at stake, there's really a lot at stake, because now we're not talking about 21 days in detention on the front end, or a commitment until you're and 19 and conditional release until you're 21, etc. No, there's a lot at stake. So just because they're children does not mean that they cannot be treated as adults. And so it's a very, very important thing. Another reason it's a very important thing. One is children in care don't want to feel like they're being treated differently and have lesser rights than their peers who are not in care. And then secondly, children can be charged as adults with adult consequences. So who is an accused child? Well, I kind of referenced it's any child, and whether it is known, unknown, or misrepresented, they're the subject of an investigation. Whether they are a person of interest, which is a term you see used on TV, but not so much in the real world, or whether the actual target or suspect. So law enforcement is, as I said earlier, is not required to be forthright in explaining why they want to speak to a child. And when they are speaking to the child, they're not required to be honest then either. And that's true of adults, okay? It's just that keep in mind that children are very naive, they're easily misled, and so this investigative technique that is frequently employed by law enforcement doesn't take into consideration the fact, in Florida anyways, the fact that a child can be easily misled, doesn't always have sufficient maturity, etc. So the only time law enforcement is required to be truthful is when they're doing it under oath, when they're providing information under oath. So that would be when they're seeking a search warrant or they're seeking an arrest warrant. And that's because they are literally under penalty of perjury when they're submitting those affidavits to a judicial officer for review. Child in care. What do we mean by this for today's presentation? a child that's not in the care of the parent based on a court order. And it can also be based on, if, for those, and I did a presentation on hidden foster care. So for those situations where there's maybe not even a court order, such as temporary custody, but also if there is a power of attorney or other type of document that's not quote unquote a court order. So for the purposes of our discussion, it could be an order of temporary custody, a shelter order, or another order that interferes with the rights of the parents. So, and the language of the order controls those rights and responsibilities that are being delegated to the caretaker. So this discussion today is helpful in enhancing or broadening the knowledge of everybody involved in the caregiving process when the child is outside of the care of the parent. And I already talked about who are the child's parents. So parents are parents until they're no longer parents. I will make a note here that, I very lightly addressed it in that emancipation presentation, but I'm going to say it here, that there are statutes that say what a medical provider must do. So the legislator has said, this is what you must do, medical provider, in order to contact the parent before you engage in any emergency or other sorts of medical procedures. And we're not going to get in the weeds on that, but just note that while we have that in place for medical providers, I've yet to find an analogous statute when it comes statute. There may be case law, but there's not a statute that clearly spells it out for the general public. So who are the child's legal guardians? If there's a court order, look at it. Does it specify what rights the third party, in other words, the person who has the child in their care, may exercise to the exclusion of the parent? Does it specify what rights that person, sorry, third party, that's lawyer speak, but because I know there's some non-lawyers watching this, may exercise concurrently or at the same time, overlapping with the parent? If there's another document, so remember I was talking about that power of attorney, which specifically rights did it delegate to the designee? Because if it's not expressed in that document, then you should presume they're still with the parent. And then also make sure specific rights that you think you can exercise have not been reserved. So a lot of these power of attorneys circulating around are templates that are not drafted by a lawyer. And in those situations, it's up to the individual to like fill in the blank in the lines. But when a lawyer does it, usually they sit down and have a consultation with the client and talk about, well, you know, what exactly is it that you want Auntie Sue to do? Enroll the child in daycare, take care of things with school and medicine, etc. So it has to just always look at your document. And then the custodian is literally what it sounds like, the person who has the child in their physical care. Does that make them the legal guardian? Not necessarily, but does that end the conversation? No, because practice tip, foster parents, non-relative caregivers, relative caregivers, and anyone else that I haven't named, but who is analogous, have an important role in protecting the constitutional rights of the child. So if you're sitting there saying, well, I'm not the legal guardian, and that ends the discussion, absolutely not. You serve a very, very important role because of your close proximity to the child. So what is a group home? A group home is a residence that's operated by a child caring agency and staffed by employees. So sometimes there's professionals who work on a shift rotation, and in that case, there may be gaps in communication, so be aware of that. And there could be less bonding and rapport. So perhaps the child doesn't trust the necessarily the adult working the midnight shift like they do the person who's there first thing in the morning when they wake up with the person who's there when they come home at night. I'm not saying that's the case, but I'm just giving like an example. Um, but either way, everybody has a role. What is normalcy? So normalcy is a term you hear a lot, and generally speaking, it's the experience, hello, back to the very beginning of what the experience of being treated the same as your peers who are not in out-of-home care. And it's the opposite of feeling like you're in an institutional setting where people are paid to take care of you and just provide the basic essentials. And so, to that extent, if you're going to stand in the shoes of the parent, because you voluntarily took on the role with that power of attorney, or you sought out a temp custody, or you worked out a consent agreement and put it into the court order, or where a judge came in and imposed this role upon you, and you said, okay, I'll do it. Whichever that is, the child needs to not feel like they're in an institutional setting and getting, just their 3 square meals and a cot. And here I've put, just for your general reference, what I refer to as alphabet soup. And these are all the acronyms, not all of the acronyms. My goodness, there's so many acronyms, but I might be referring to these throughout the rest of this presentation. In your materials, there's a much more extensive list. And also, I actually picked this straight up from a judge in Miami-Dade who, the first time I appeared in front of her, I heard her, because she was an appellate attorney previously, she's very clear to make sure that, one, the record is clear as to what the letters stand for, but also so that all the people in the room, especially the ones who aren't every day dealing with the system, know what these things stand for. And I've picked up this habit, so now I sometimes hear letters that I'm still not familiar with, and I've been doing this for a while. And so I will ask, and I think everybody should feel comfortable asking, well, when you said DGY, what did you mean by DGY? Because people forget that we don't all speak the same alphabet soup language. So here's the rights to be protected. In the focus here is the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment. And what amendments are they? Where are they found? They're found in the Bill of Rights, attached to the Constitution. And so that was our original drafters, right? Way back when. I think we're celebrating 250 years of this coming up soon. But in any event, these are the ones we're talking about here today. And a lot of you have probably heard of these over the last year or so in the context of other situations that are in the news, but we're going to be talking about them very specifically with some scenarios in the context of children in care. And then the Eighth Amendment, I know we rarely ever hear about this unless we're paying attention to death penalty litigation or civil rights litigation. So that's a very, very narrow class of people. So the Eighth Amendment is what we're referring to as cruel and unusual punishment. So now let's talk about those a little bit more. Here's the actual language from the Bill of Rights. For the Fourth Amendment, these are the rights that are protected, okay? And so what are we talking about here? We're talking about being secured against having safety and security in your person, so you're not going to get seized without a warrant, that your houses are not going to be entered into, and that your things, your personal belongings, whatever they may be, and now digital, not just in paper, are not going to be searched and seized unreasonably. And if there's a warrant, it has to be on probable cause, supported by that oath that I talked about earlier, that's reviewed by a judicial officer, and that particularly describes the place to be searched and the person or things to be seized. So pretty much this whole Fourth Amendment is when we talk about warrantless searches and warrantless seizures. Okay? And you remember that movie where they were always saying, show me the money? Just think of the Fourth Amendment as show me the warrant. Okay? Here's a scenario to give it context, so we're not just dealing with something abstract. And I'm just using this not because of any particular case. This is just something that popped into my head. So law enforcement arrives at the non-relative caregiver's home. The parent's rights are still intact. Law enforcement asks the caregiver to give them Warren, think Warren, warrantless, phone. And the phone has biometric authentication. So what is biometric authentication? That's for people who do it, it's the fingerprint scan or the eyeball scan. So law enforcement can't grab Warren's phone, hold it up to his eye, stick his finger on the sensor, and can't force Warren to put the passcode in order to open the phone. They can't even take the phone from him without a warrant unless, and this is just so you know what the rights are so that you can then assert it. Are there exceptions? Absolutely. Is that the purpose of this presentation? Absolutely not. It's just to give you an awareness of those rights and how you can help the child protect and invoke them. So the Fifth Amendment, this has to do with speaking, right? And it has to do with a whole lot of other things, but where are we going to focus? We're going to focus on nor shall be compelled in any criminal case to be a witness against himself, herself, themselves, nor be deprived of life, liberty, or property without due process of law. Actually, for our purposes, we're just going to stop compelled to be a witness against himself. So, part 1 of your Miranda rights. You have the right to remain silent. I call it the zip it right, okay? For those of you who, I don't know if they still use this expression, or maybe grannies and aunties do, but zip it, right? Keep your mouth shut. So here's our scenario. Law enforcement calls the DCM and asks her to bring Zane to the substation nearby. Law enforcement, because it can, gives a vague, ambiguous reason when the dependency case manager asks why. The dependency case manager drives Zane to the substation and waits in the lobby. So that's our scenario. Think about it, because at this point, no one knows why they want Zane to come down to the substation. Or they give a reason like, oh, well, we think he was a witness to a crime, right? There's a good one. Oh, how helpful. Let's help him be a good citizen and help law enforcement out. Except that doesn't actually have to be the reason. They can give what's called a pretextual reason, a disingenuous reason to get Zane down to the substation. Our Sixth Amendment, the right to what? The right to counsel. So, second part of the Miranda rights, you have the right to remain silent, number 5. You have the right to an attorney, number 6. So for our purposes, we're not concerned with the right to speedy trial. We're not concerned with, for our purposes today, we're not concerned with an impartial jury, or where the people who can compose that jury are composed, who they are composed from, or even the right to be informed, or even the right of confrontation. So there's a lot of rights in the Sixth Amendment, but the very last clause, and to have the assistance of counsel for his defense. So that's a lot of words before we get all the way down to the bottom. To have the assistance of counsel for his defense. And for the nerds out there, in re Galt is a very important case that talks about a lot of these rights, and it's in your materials in the case law. And in re Galt just had a birthday, like an anniversary, a short while ago. So you might have heard about it in the news. So here's a scenario involving the Sixth Amendment. Law enforcement arrives unannounced at a group home. They ask to speak to Lauren. The staff member gets the designated reasonable prudent parent, designee. So we're going to talk about this in a little bit, but a reasonable prudent parent is the standard by which anybody who is the caregiver for a child must act. It's a statutory standard. Case law is in your, or the statute is in your packet. But so it's a staff member. They're maybe not trained on this. They don't know what to handle. So they call the designated person. And law enforcement tells the designee, and that's the first person they call, and they put them on the phone. And law enforcement tells the designee that Lauren doesn't need an attorney. This is a non-custodial interview. We can do it the easy way. And they just have a few questions. So that's the scenario. And how does this impact the right to counsel? Because they're saying, Lauren doesn't need an attorney. This is just an interview. We're going to be speaking to her here in the home. And then the Eighth Amendment. First half has to do with excessive bail and fines. The part that I want to focus on for today's purposes is nor cruel and unusual punishments inflicted. And the important thing to remember about that is that punishment doesn't necessarily have to be pursuant to a sentence. From the moment the child is taken into custody and under the government's control, all the way through to the end of whatever, okay? All that time, they should not be subjected to cruel and unusual punishment. And I want to direct your attention to, there's a really good law review article in the materials about the effects of sleep deprivation. So here's our Eighth Amendment scenario. The dependency case manager drops Carly off at the lobby and leaves because there is an emergency with another child, and that child has experienced trauma, and the DCM is like focused on that trauma that child experienced. Kind of one of those very consuming scenarios. And the DCM has, in the back of her mind, just assumed that there's been an arrest. So I've been told to bring Carly down. I bring her to the lobby, but I can't stick around. I leave, and I don't see what happens next. And Carly is supposed to appear if she's being arrested. She didn't come home. She must have been arrested. A lot of assumptions are happening. Carly should appear at detention hearing court the next morning. Another assumption. Turns out law enforcement did not produce Carly at the DJJ Judicial Assessment Center for over 48 hours, and Carly was held in solitary confinement without food or water after she invoked her Fifth and Sixth Amendment rights to remain silent and to speak with a lawyer. Okay, so keep those scenarios in your mind, and then we're going to come back to what would you do? Or what should you do? Speaking of what you should do, let's talk about responsibilities. So the responsibility of those standing in the shoes of the parent, and I have 3 steps here, right? Let's work from the top down. So moral responsibility is ethically what we aim for, what we aspire for, and in this case, what we can do. You can do it. I'm not asking anybody to do the impossible. You're capable of helping this child protect their constitutional rights. So you can do it. What is the least you have to do? That's a legal responsibility. That goes to liability, right? This is a lot of what trainings are focused on, is just make sure you protect yourself, your institution, etc. This is what I call the floor, okay? The moral responsibility is where all human beings are capable of acting, okay? So, and then we have abdicating responsibility, and that's below the floor. That's where people, in the face of something that they can do, that they should do, and they just do absolutely nothing. Not my problem. Or even going another step, not doing nothing, but engaging in conduct which does not protect the child's constitutional right. Oh yeah, here's the phone. Oh yeah. Here, come on in and look in the room. Here's his backpack. Look through the backpack. Zane, go ahead. Sit down here in the kitchen. I'm going to go run some errands and do some yard work. You speak with this nice law enforcement officer. So who are the people who are involved? What I call the job descriptions, right? The people who can do something. There's two folks at the front end, and when I say at the front end, who interface with the child in a professional manner. We're going to go through all of them. It's just not these two. But the first two we're going to talk about is the attorney ad litem and the guardian ad litem. And the role of an attorney ad litem is to investigate, offer advice and counsel, and protect the client's constitutional and statutory rights. Why? Because the rules of professional conduct require us to. We have to abide by our client's decisions, but we also provide advice and counsel with the exercise of independent professional judgment so that when they do make a decision, it's fully informed. It's not whimsical, it's not arbitrary, but it's based on advice and counsel. And some of us here know that you can give even an adult client the best advice in the world, but ultimately, they're the ones who live with the consequence. And so after the client has received this advice and counsel, what's their decision? And the attorney ad litem maintains confidentiality and attorney-client privilege. I call it putting it in the vault, right? So whatever you tell me goes into the vault, and you, the client, are the only one who can open the vault, whether it's with a key or a combination lock. And our obligation is to avoid conflicts of interest and maintain loyalty to the client. And so how does an attorney ad litem come to be? Well, they're appointed by the court to represent the child in a dependency case, and they have an attorney-client relationship. How does the attorney ad litem engage or interface with the child's constitutional rights in the context of a criminal or delinquency investigation? Well, they're not the defense attorney, right? But they have knowledge about the law, and they're charged with protecting the child's rights, so they can assist other adults and they can advise the child in asserting those rights. Now, the role of the guardian ad litem is to also investigate, but to provide community advocacy and legal representation to protect the child's legal interests. And defined by statute, it's a fiduciary appointed by the court to represent a child in a proceeding to which the child is a party and uses a best interest standard for decision-making and advocacy. So notice that the attorney ad litem doesn't use a best interest standard. They are there to give advice and counsel as to how to make sure that that child knows how to protect their constitutional rights. What's not present is the attorney-client privilege or confidentiality. So they don't have the vault. And what does that mean? That they can be called as a witness, just like a parent can. Florida does, I had somebody in a deposition once invoke the parent-child privilege. And it was an adult, but he's still the mother's child, right? So no such privilege exists, just like there's no statutory privilege for any other person. And I know for a fact in the context of our cases, the attorney ad litem has that privilege, and with very finite exception, if ever, and then the therapist. And it definitely depends on the role of the therapist. So I don't want to get in the weeds about that. But just know that a very savvy prosecutor or a very savvy defense attorney, either way, if you've had conversations with the child about the content of a criminal investigation, you can be called as a witness. The other thing that a guardian ad litem should be mindful of is that their role in protecting the child's legal interest includes not waiving those rights. So not being that person who voluntarily turns things over. If you receive a subpoena, that's one thing, but voluntarily waiving that child's rights without their consent is not part of the role. And just remember that a statement a child gives can be truthful, but inconsistent, and for reasons that have to do nothing to do with inculpating themselves. It could be because of impaired memory due to trauma. It could be impaired recollection because of immaturity. You have no idea what's going on in their brain and their ability to process and retain accurate. And then I don't even want to get into, there's a whole legal field on in psychology on the accuracy of witness testimony. So other job descriptions that come into play in the protection of a child's constitutional rights. The role of law enforcement, the juvenile probation officer, and the dependency case manager. They're not aligned. They're not aligned. I'm just putting them on the slide because they're non-lawyers and because they sometimes and often are helpful people, but their roles are different. So let's talk about the role of the law enforcement officer. It's a person who's given, this is a statutory definition of a law enforcement, a person who, the first clause, a person who's given the power to make arrests and whose primary responsibility is the prevention and detection of crime or the enforcement of the laws of the state. So as much as we love community policing, that is not necessarily, it goes towards prevention and detection, but it's not that their primary role is to be a social worker, to provide referrals. Their training is sort of how to handle a problem and how to handle a problem a certain way. The role of the juvenile probation officer, and this can be found in the FAQs on the Department of Juvenile Justice's website. They deliver case management services to the child. They're the frontline staff member who interfaces with the child and the family. And family should be broadly defined. We're not talking about genetic necessarily. For the most part, the child's JPO is the single point of contact as the child moves through the juvenile justice system. And this, I think, is very important here. They recommend how to handle the child's law violation. It's a lot of power, a lot of responsibility. But it can be exercised in a variety of different ways, and you don't always know what the internal policy of that office or what have you on how they're going to exercise that discretion. And the role of a juvenile probation officer, I like this because I think it's pretty accurate. It's a blend of surveillance because they always have to keep an eye on the child, and rapport building because they get that case at inception. So even though the child has not been disposed, hasn't been put on probation, hasn't been committed, from the moment of arrest, there is, or within a day or so of arrest, there's a juvenile probation officer assigned, which for people who don't necessarily deal in delinquency all the time, it's off-putting because you're like, why are they involved? The child's not on probation. Well, because in juvenile justice, in delinquency matters, the juvenile probation officer is there from the beginning to offer voluntary services, and the key is voluntary. Oh. And then here we have, oops, I went one slide too far, sorry. The role of the DC, the dependency case manager. And where did I find this? I found this in Appendix A to an operating procedure, but I think it's a pretty good description. It's a person who's accountable for service delivery regarding safety, permanency, and I want to focus on the word well-being, okay? The well-being for a caseload of children in out-of-home care. So protecting well-being, that's why we're here today in this presentation. Why I'm presenting is because well-being includes protecting that child's constitutional rights, okay? That child has the right to have their constitutional rights protected to the highest level possible. And there's no difference. I'm going to keep harping on this throughout the slide so it gets through. These children need to be treated exactly the same as every other child, regardless of whether they're in care or not. So here are some very concrete ways a dependency case manager and also the other folks that we've been talking about can exercise these constitutional or help protect those constitutional rights. They can ask law enforcement to produce the search warrant when the law enforcement officer wants to and would like to obtain property from the child. Ask law enforcement produce the search warrant when they want to obtain fingerprints or a cheek swab or a blood draw or any property from which those things can be obtained. So a drink from the nightstand, a toothbrush, a hairbrush, seems innocuous, right? Those things belong to that child, and because they belong to the child, there needs to be a search warrant. Reflect back to that Fourth Amendment. So when law enforcement wants the child to be presented to them, and regardless of where they want the child to be presented to them, whether it's at the kitchen table, whether it's on the back patio, or whether it's down at the substation, ask law enforcement to produce the arrest warrant. Because remember, these children have a right to be free from unreasonable seizures. And the way you know that it's a reasonable seizure is because a judicial officer has reviewed it and approved it. Tell law enforcement that the child has a right to consult with an attorney and with his parents. Now, if the parents' rights are no longer intact, so we have a final judgment terminating the parents' rights, that parental role may not be necessarily intact, but there may be people who serve in that parental role. So he has a right to consult with a parental figure of his choosing, as well as with an attorney. And this next one should probably have gone at the very top before anything, but, law enforcement's there, they're in, big and bulky, they got their body-worn camera on, and I want to talk about that in a minute too. but notify the attorney ad litem and notify the parents immediately. The people who have that close proximity to the child may know exactly what app to, like how to reach out to the parent, with the WhatsApp and the text now. It may not necessarily be a phone number that can be found in traditional manners. It may be on the face sheet, but out of date. So the attorney and the ad litem and the dependency case manager are probably the people who have the most up-to-date, accurate contact information for the parents. Don't trust that what is on that face sheet, if the child even has a face sheet, is accurate. And then explain to the child what zip it means, right? Literally anything you say can be used against you. And that there's no talking your way out of it. How many of us know, whether it's our own child who thought that when they committed some sort of offense, such as knocking over a vase, I don't want to be de minimis, and they thought they could talk themselves out of it, right? There is, even for adults, there is just no talking your way out of it. The minute the child opens their mouth to begin speaking, they don't know what law enforcement knows. So it's always better to just zip it and literally, and then put a lock on it. So just remember that in that role, protecting the well-being of a child includes protecting that child's constitutional rights. The role of the foster parent and the role of staff at a group home. We're going to talk about those next. And there's no necessarily any particular priority or reason why I broke these down in the way that it was. It wasn't because somebody has a lesser primacy or importance. It's just the way it logically in my brain, I could categorize them for purposes of this presentation, but there's no legal primacy or importance. Other than whoever's closest to the child and has that closest relationship. When we talk about proximity, it could be physical proximity. So you have the ability to interface with law enforcement, and also the people who have that closest proximity in the sense that they have the most trust in that person and trust that that person is going to protect their constitutional rights. So the role of the foster parents, well, it's a person who's approved by somebody to provide out-of-home care for the child. It could be the parent who approved the person. So I'm speaking in a broad foster parent sense, not the legal narrow sense. You're approved to provide out-of-home care for the child. It could be through the, like I said before, the power of attorney. It could be through a agreed to consensual court order, or it could be someone who the court through the department delegated the responsibility to. So very clear, and I think I've made it very clear up to this point, that as long as there is a parent, no one has the legal authority to override their decisions when it comes to constitutional protective rights. And the parent is giving advice and counsel to the child. And so the foster parent, likewise, should be mindful of their role in the larger sense of outside of protecting the constitutional rights of the child. Major decisions. So let's think about the things that you have to go back to court and get an order for. Passports, anesthetic surgery, psychotropic medications, and placements that impair the child's liberties, such as residential treatment centers. So think of those: anesthesia, psychotropic medication, and residential treatment centers. Not to weigh one thing against the other. Those have to do with constitutional rights to like bodily integrity and privacy. But on top of that, we have these express rights that are word for word in the Bill of Rights, and that is the right to be free from unreasonable warrantless searches and seizures, the right to be free from being compelled to speak with law enforcement, the right to remain silent, and the right to consult with an attorney, the right to counsel, and the right to be free from cruel and unusual punishment. So don't think that like, okay, well, I have to get a court order for those things. Should I get a court order for this? No, because of that primacy and the close proximity, you're allowed to guide the child when the parents are not immediately available, when the attorney ad litem is not on your speed dial, and maybe they have the do not disturb on at 2:00 in the morning. So you can step it up and say, I'm the first to know of this legal issue. I'm going to notify the child's attorney. I'm going to notify the dependency case manager. And so while you lack the final legal authority, you can use that reasonable and prudent parent standard, and you can protect those rights to silence. You can notify, you can question, you can help the child assert their constitutional rights. And the role of the staff at a group home, I kind of talked about that in one of the scenarios, right? So you have to have the person that's designated for making those reasonable and prudent parent decisions. And just as I applied that just now to the foster parent, I want to apply it to the staff at the group home. That they make those reasonable, prudent, and reasonable, prudent parent decisions. Well, I can't reach the parent. What would a reasonable, prudent parent do? A reasonable, prudent parent would protect that child's constitutional rights by asserting them and helping the child assert them and making sure they didn't leave the child in scenarios where the child could be talked into waiving them. So let's go back to our scenarios. Law enforcement arrives at the non-relative caregiver's home. Now we know what we know, right, about these rights and the roles. The parents' rights are intact. Law enforcement asks the caregiver to give them Warren's phone. The phone has that biometric authentication. What should the caregiver do? And it can be more than one thing. In fact, it should be more than one thing, right? So I'd be curious to not see now because I can't actually see the chat. But if you want to drop in the chat what you think the caregiver should do, just go ahead because we'll share this information later so everybody will see it, and you can have a dialogue. And we can dialogue about this when we get to the question period, which is coming soon, I promise. Okay, so after hearing what I just said, what do you think should be the first thing that they do? Call the parents, right? The parents' rights are intact. Call the attorney ad litem, if there is one. Tell the child, not without a warrant, including the password. Tell law enforcement, not without a warrant. If law enforcement has probable cause, they can go to a judicial officer. They can go and present the reasons for why they have probable cause to search, to have this item in their possession, and to search it. It has to be reviewed by a judicial officer. Again, there are exceptions, but when you say you're preserving your child, the child's constitutional rights. So call the parents, let them know what's going on, call the attorney ad litem, let them know what's going on, and tell the child, not without a warrant, including your password and your biometric workarounds, and then tell the law enforcement officer respectfully, you don't have to get nasty, but just when you come back with a warrant, we'll be happy to provide it to you. Okay. And you know what they do? So now they have the phone, but they still can't get into the phone without a warrant that gives them permission to get into the phone. So make sure you read that warrant and when they do come back and what it gives them the right to seize. So don't just take them at their word. Make sure you read the paperwork and phone a friend if you have any concerns. And by that, I mean an attorney. Okay. Moving on. And if you recall, I said we're not going to go down like the rabbit holes with all the exceptions because there's entire classes that go on for 4 months, 3 or 4 months in law school, teaching just like the icing on the cake of these rights. So this is just enough for you to know, hey, something's funny here. I should help this child help themselves. All right, so now we have law enforcement calling up the dependency case manager and asking the case manager to bring Zane to the substation with the wishy-washy reason why. And let's back it up. At that point, should the dependency case manager drive Zane to the substation? And why not? Is there any requirement that they do that? Is there a warrant for the seizure of Zane? There is not. Because if there was, law enforcement would come and execute it. And the only time they wouldn't do that is if, in my experience, Zane has a lawyer and they worked out a surrender so that Zane doesn't get traumatized. You want to drive down there on your own without Zane and say, may I see the arrest warrant? That's fine. If you want to say, hey, can you email that to me? Who uses faxes anymore, but can you email that to me? Take some screenshots and send it to me. I just need to review it. I need to have the attorney review it, the attorney ad litem review it so that but generally, I mean, you're not going to get into the weeds in that review, but you're going to just say, I want to see what it says, right? It is very rare in my experience that they would call up and ask you to bring the child there if they already had an arrest warrant. So first thing you do is say, is there a warrant? May I see it? While you're waiting for it to come in, you call the parents, call the attorney ad litem, assist the child in telling the police. Again, if you want to drop, anytime we get these, just go ahead and drop them in the chat before I start speaking. Tell the police the child does not want to speak with law enforcement. And then here's a couple of, well, I'm going to see if anybody comes up with what, after that's done and resolved, right? What can be done proactively in the very near future? I didn't talk about this, but I want to see if anybody can think, what could the dependency case manager do? And if it's not in the chat, I'll remember, or Robin will remind me to come back to this. Because I want to see if anybody can come up with what the dependency case manager could do in conjunction with child legal services, something that they could do in a courtroom to help proactively help this child protect their constitutional rights. So this is going to blend the 5th and the 6th together. The dependency case manager should tell law enforcement that the child needs to speak with an attorney first before there's any further conversation, that the child needs to speak with their parental figure whether it's an actual parent or someone who stands in the emotional nurturing role of a parent, before there's any conversation. And remember I said I wanted to talk about body-worn cameras again? If law enforcement is in your presence, in the child's presence, make sure that the body-worn camera is activated, so you should be able to see a light. And know, I think everybody forgets this, but know that at least in Florida, there is a 30-second delay. So you may think that the body-worn camera is on and is recording everything that's being said, but there's nothing, to my knowledge, nothing that can be, because I used to be on the other side and I would have loved to know what was said in those first 30 seconds. But those 30 seconds are visually recorded, but there's no audio. So just be mindful of that. And wait, even if you want to wait the 30 seconds after you see them push the button, just say, I just want to wait for the audio to come on, officer. And then together you and the child can assert the child's rights. Our Sixth Amendment scenario, they want to speak to Lauren without a lawyer. Lauren doesn't need a lawyer. This is just a non-custodial interview. Come chat with us out front, adjacent but not inside of our police cars. Okay? Do you understand what I'm saying? It's a non-custodial interview. We're just here to have a chat. It's very non-custodial because we're just standing next to our police cars. You're not in the car. You're not in handcuffs. We don't have to get into the legal niceties. Just know that just because it looks pleasant doesn't necessarily mean that it's appropriate to waive the child's constitutional rights. Okay? Always, always, always better safe than sorry. What should the group home designee do? Invoke that right to counsel, invoke that right to remain silent, call the parents, call the attorney ad litem. And if there's no attorney ad litem, what do you do next? The next day, next business day, when you have access to the assigned CLS attorney or their supervisor. And then here we have that Eighth Amendment scenario, okay? You don't have to know if under the case law, whether or not this being held in solitary confinement for 48 hours without food or water and the access to any outside advice or guidance or humanity is cruel and unusual. You don't necessarily have to know that. You don't have to be a legal scholar and figure out what the actual correct answer is. It doesn't look right. It doesn't seem right. It doesn't comply with the ordinary experience. So, yes, the child properly invoked her Fifth and Sixth Amendment rights, but that doesn't mean she waived her Eighth Amendment right to be free from cruel and unusual punishment. So, think about folks who are detained long-term without access to the courts, and the treatment of that. And that's, remember when we were talking about the cruel and unusual punishment under the Eighth Amendment. Is there anything that you can do prophylactically at that point? Preventative-wise? Not necessarily, but there are remedies, right? And the remedy is to call the attorney ad litem, to call the parents. Why? Because there are at least two things that immediately come to my mind. One is a habeas corpus petition where you ask not you, the non-lawyer, but a lawyer asks the court to produce the body of the child because no one knows where the child is. And then there could also be, you don't need to know whether there is or there isn't. You just need to know it's a red flag, spot that issue. And is there a 1983 violation? What is a 1983 violation? That's a federal civil rights violation. And what federal civil right is being violated, the Fourth Amendment, the Fifth Amendment. I'm sorry, not the Fourth Amendment, the Eighth. Maybe those other ones, but you definitely know it appears that the Eighth Amendment is being violated. So, do you need to be a lawyer to know these things? No, you just need to know that it just doesn't sit right, and there are things that can be done to get that child out of that situation, and to provide remedies. So this is a good example of always needing to know where the child is to stay on top of it. And the minute that things are not going in the right direction, they're supposed to be in court the very next day, or that afternoon. And if that doesn't happen, raise the alarm. And then consult with the CLS attorney assigned to the case, or their supervisor, or their supervisor's supervisor, and think about what should be done next, which we'll get to in the Q&As. So here's, to wrap up, I just want to go over probably 2 or 3 more things. One is the Kaya. It's either Raleigh or Roll. I know this last name because it's very common down here in South Florida, but I still don't get it right because everybody pronounces it differently. But who was she? She was a 6-year-old, and she was acting out in school, and she was arrested. And there was witnesses, whether it was audio, visual, or live witnesses, who heard the law enforcement officer joking about, the youngest child he'd ever arrested was 7. This was the first time it'd ever been a 6-year-old, and how many hundreds of arrests. And I don't know if all that went into passing the law, but I do know that the way that this child at 6 years old was treated caused the legislature, or at least that's how it's presented. It certainly got a lot of publicity at the time. And they passed this statute. And the only thing I want to say is that, this is a Florida difference. So our 6-year-olds and under may not be arrested, right? May not means cannot be arrested, period. So knowing that, and there are sad things that have happened. When children under 6 come into contact with law enforcement. Now, there's an exception. There's an exception when the violation of law is a forcible felony. And in the small, and these are what forcible felonies are defined as in that statute, okay? And are 6-year-olds going to be committing these crimes? Not in the ordinary course, but what if somebody thinks that unlawful throwing of, I don't know what a destructive device could be, a glass bottle of water? It's not, but somebody might not know better and could bring law enforcement out, and an uninformed law enforcement officer could make that arrest. Or a 6-year-old could, or a 6-year-old could technically, I guess. I mean, I couldn't understand why they would put these in here, but there's going to be a scenario where a 6-year-old uses the threat of physical force or violence, commits a felony, so like aggravated assault, and maybe they have something in their hand that's, so we're really getting into the weeds, but just be aware there are occasions when a 6-year-old or a 5-year-old can, or even younger, can be arrested. We're not talking about competency. We're just saying that there's a ban for certain behaviors that don't rise to forcible felonies. I just thought it was a unique Florida difference. Okay, so what we can learn from others. If you've ever seen my presentations, I like to talk about what other states do because they do some really cool things. And this slide tells you about what those other states are. You can click on the link, but I've also included and that website, but I've also included like a printout, if you will, PDF. And we have different forms. So law enforcement in the first 4 states, Delaware, Illinois, Oregon, Utah, cannot use deceptive tactics, like I was talking about, in about evidence. Oh, I have this, I have that. They don't have to have it. They can misrepresent that truth. Like, oh, we have you on video doing such and so, or promising, oh, don't worry, I'll let the prosecutor know to go easy on you. You can't do that in those states. Nevada and Utah also have statutory language which requires a simplified version of Miranda rights for young people because, brain science shows that 12-year-olds are not the same as 32-year-olds in terms of processing and comprehending information. And actually, the international chiefs of police have signed on to this simplified version of Miranda rights. So some states, including California, Illinois, Maryland, and Washington State, have adopted legislation that says youth, young people, children, must speak to a defense attorney before they waive their Miranda rights. And Colorado, Indiana, and Nevada say a little bit not as strong as what Delaware, Illinois, Oregon, and Utah did about you just can't even use these tactics. In Colorado, Indiana, and Nevada, they say if you use these tactics, the evidence is not admissible. So I just thought that was very interesting. And if anybody is into policy, there is room for improvement in the state of Florida on those issues. We can always be better. Oh, why protecting the rights of children in care matters. Why did we just spend an hour and 20 minutes together? Because shocking statistics for most people. I hope it's shocking. If you've ever worked in various different roles like I have, sadly, it's not a surprise because of what I've seen with my own eyes. But 25% of former foster care youth will become involved with the criminal justice system within 2 years of leaving care. And underrepresented minorities, marginalized people, such as Black youth, LGBTQ plus youth, and those with mental illnesses are more likely in the first place to be in foster care. So therefore, they're more likely to be represented in this 25%. And it really makes, once you have that contact with law enforcement, it has effects on foster youth because it can impact their treatment and the placements that are available for them. And it's called, you've heard the school to prison pipeline. There is literally a foster care to prison pipeline. And so it's not just data. I've known young people who were 14, 15, 16. That would have been in the years between 2013 and 2017. And then in 2024, they were already in felony mental health court and incarcerated. So a significant population of them. So I just want you all to know that there are consequences. It's real life and it has adverse impacts that follow these children as they move forward with their lives. And it creates burdens and obstacles and barriers that we know that not with the same percentages, not with these 25% percentages, are you going to see that in children who did not enter care. All right. So the answer to the question, whose job is it? It's our job. It's our job collectively as a community caring for children in care, and it's our job as individuals to make sure that we protect the rights of the accused child in care. And now, I know we have 5 minutes to open it. Sorry, but we're going to open it up to questions and answers. And
All right.
at At 1:30, I'm going to move the slide on. So just remind me when it's 1:30. Thank you.
All right. So thank you for an amazing presentation. Lots of content. I've been dropping some links in the chat as we've been going along. I've included links for all of these materials, including the slides and a Dropbox folder that Janine set up. I dropped the information for the CLE code in the chat, but we will have a slide afterwards, so I'll read it out loud after the questions. We do have a few questions pending in the Q&A, and I'm going to read them out loud for the benefit of the audience. The first question is, search warrant, does it need to be signed by a sitting judge within the last 30 days?
Okay, the 30 days issue, I don't know. It definitely needs to be signed by a judge. The question is whether or not that probable cause is stale. And I mean, at that point, you should consult an attorney. Okay. Uh, if you are an attorney asking that question, I can point you to where you can find the answer. I just don't know it off the top of my head.
All right. The next question is, please also discuss the importance of having an attorney appointed at arraignment and not pleading to a charge without an attorney.
Oh, okay. Sure. So my focus for today was on the pre-arrest or pre-arraignment, I should say, or first appearance. So at the time the child comes into detention, they should, within 24 hours, be brought before a judge. And at that hearing, they should be informed of their right to counsel. If they're indigent, which most children in care are, unless their master trust is like seriously overflowing with funds. I had today, most judges just say, oh, this child's in care, I'm going to appoint the public defender. The public defender has a conflict. Eventually, they'll let the court know, and the Office of Regional Counsel will be appointed. But just like all these rights needed to be protected, when you get to the goal, it's not, I don't want to call it the goal line, but let's say you get into the red zone, if you know football, like the 20-yard line, which is when you're in your first appearance before court, you absolutely should have an attorney. That lawyer should be appointed to you. And if you don't have one, you should ask for continuance so that you can look into getting an attorney appointed for you. Because there are children in care whose parents' rights are intact and who have the means to hire an attorney. Maybe they want to do that, maybe they don't. There's different ways, different circuits look at whether it's the child that's indigent or whether it's the parents that are indigent.
I
And there's
think
case law on this. So
I think, Janine, the concern was sometimes children get convinced to enter a plea without having an attorney. And so folks that are around that child should make sure that they don't enter an uncounseled plea.
yes,
I
that's
think
what you ask for, a continuance to, if you're not getting appointed a public defender that day that you can speak to, and when I say a public defender, any government paid lawyer. So it could be a public defender, it could be the Office of Regional Counsel, it could be a lawyer that's on the wheel or the registry when there's a conflict of interest. But that lawyer should meet and confer and explain everything to the child, especially after they've received all the discovery.
So what if they say there's no lawyer today? So you could either, if you want to go home, you could enter a plea, or you'll have to come back tomorrow to have a lawyer. Does that ever happen?
So that right to counsel, that Sixth Amendment right to counsel, should never be waived. These children are entitled to lawyers and they need to have a lawyer. So anybody who's trying to offer a plea to a child to go forward without a lawyer is putting, I just think that would be, it would need to be clear on the record. The judge is going to do a colloquy. You can at any time say, no, I want a lawyer. I want a lawyer. Like this really, and there's in the materials and best practices, there are know your rights cards that you can give to children. So there's no reason that I'm aware of without counsel, a child should be considering entering a plea of no contest or guilty. The plea should always be not guilty. If you don't have a
All right,
lawyer,
so
obviously you have a lawyer, they can tell you what they think is best.
we're at time, it's 1:30, Janine, so I guess that's a good time to move to the next slide with the CLE code. I dropped it in the chat, but I'm gonna go ahead and read it out loud. The CLE code is 2603276N as in Nancy.
And
That
then
will also be going out via email and in the YouTube description as well. Yes, Janine, go ahead.
And so there was one thing I said I wanted to circle back with, and I can't see the chat, so I'm afraid I'll lose like my ability to see other things. So I just wanted to say, to answer to the question that I posed, which is what should be the thing that the dependency case manager does as soon as the CLS attorney picks up their phone, and that should be move the court to appoint an attorney ad litem for the child. Is it going to be a statutory right? No. But at this point, you're trying to protect the best interest of the child. You're trying to make sure that the child's constitutional rights are protected going forward, and they should have an attorney ad litem by their side. And that's the end of it. So thank you so much. And if anybody wants to reach out to me, I'm going to be able to see all these chats and Q&As, and so I'll respond to each one of you one way or the other if I have access to who you are. And then you can always contact me.
I was gonna say somebody asked about the CLE number. It's on the screen just in case the complete number is 2603276N as in Nancy. And by the way, Janine, I'm dropping another link here. This is the page that I had mentioned. This is where I'm putting together all of the webinars, all the series info. You will find how like the next few webinars so you can register for them, but you can also find not only the playlist, but you can also find a list of every the most recent webinars that we posted. If it's a little bit easier for you, you will find the CLE codes in there, so it's all there in one place.
And I'll tell you what, when I do the answers to the questions, I'll create an FAQ and I'll put that in the materials too.
Beautiful. All right, it's 1:32. We're a little bit over, but I wanted to thank everybody that joined us today. And thank you, Janine, for leading another amazing webinar. It was really informative, and there's a lot to absorb. So thank you, Janine. Thank you, Robin. We'll see you at the next one next month. All right.
Thank
Have a
you.
good rest of your day.